Kari Lake scheduled for trial, and there's going to be some interesting new revelations, but we're going to look at the docket before we see what the judge said in his recent Under Advisement ruling, which actually threw out several different complaint charges brought forward by Kari Lake. It is scheduled for trial on the 21st and the 22nd, and let's see what the docket has for us. If we click over to the clerk of the court website, you can see there's been a lot of activity recently today. Several documents were filed by some of the defendants. One you see here is from Katie Hobbs. The other is on the next page, which is from Stephen Richer, which is the Maricopa County recorder. But take a look at these two motions. You can see they are emergency motions to reconsider the request to quash the subpoena. This is Katie Hobbs asking the court a second time to please allow her to not testify. And it's an emergency. Why? Because trial is scheduled tomorrow. So as you can see, we've got two of these similar requests, motions to quash the warrants from Katie Hobbs and from Stephen Richer. Let's go through them one at a time. You can see here, filed 12/19/2022 from Arizona Secretary of State Katie Hobbs. This is her emergency motion, to reconsider the order denying the motion to quash. This means Kari Lake filed a lawsuit. She is the plaintiff suing Katie Hobbs. She needs Katie Hobbs to come and testify at trial. She got a subpoena that got delivered to Katie Hobbs. Katie Hobbs wants to quash the subpoena. She filed a request to quash the subpoena. The judge denied it. Said, no, what are you, nuts? You're the Secretary of State. It's your election. You got to be here. So she's filing an emergency for reconsideration. The judge already denied her to do it again because she really, really doesn't want to talk. Defendant Katie Hobbs in her official capacity is here in front of the court now. We are asking the court to reconsider, to please change your opinion. In denying the secretary's first motion, Katie Hobbs's lawyers, they write, the court noted that given the nature of the case, this is the judge speaking, where the questions of fact range from technical minutia to broader issues of election manual interpretation, the judge said the court cannot say that the testimony is completely irrelevant or even marginally relevant. The judge is saying, we kind of need her. I mean, she's the Secretary of State. The court further noted that the subpoena seeks discovery concerning an activity wholly within her wheelhouse, all right? The conduct of the elections. She is the Secretary of State after all. But so that's what the judge said, that why she needs to be there. Well, she's the Secretary of State. She conducts the elections, kind of relevant. But Hobbs's lawyers, they say, but in an order issued at that same time, right? This is in response to yesterday's order, which dismissed 8 of the 10 counts that Kari Lake brought, which we're going to talk about next. The narrowing of the scope of the 2 remaining counts is going to proceed to trial. And so now that we don't have those other 8 counts, right? What they're saying is Katie Hobbs may have been needed for these 8 counts. But now that 8 of them have been dismissed, the remaining 2, Katie Hobbs is not needed for those. So there's been a substantial change. And so now good cause exists. Now the court can reconsider our prior request. There's been a material change in circumstances now, since 80% of the claims have been dumped. So Hobbs's team, they write, under the motion to dismiss order, only 2 narrow issues will proceed to trial. They write under count 2, to the extent that the plaintiff alleges that a person employed by Maricopa County interfered with the board of director printers in violation of Arizona law, resulting in some number of lost votes for plaintiff, meaning that plaintiff, Kari Lake, is entitled to attempt to prove at trial that 1, a malfeasant person was covered under Arizona law, 2, that the printer malfunctions caused by this individual directly resulted in identifiable lost votes, and 3, that those votes would have affected the outcome of the election. So Kari Lake has to meet all of those things. A malfeasant person, so some sort of error, right, or some sort of negligent, not even negligent, sort of intentional misconduct, malfeasance. 2, printer violations directly resulted in identifiable lost votes. And 3, it affected the outcome of the election. Okay, an extremely tall order. We've covered these standards before when we covered all of the 2020 litigation. Extremely hard. Because they're just going to come out and they're going to just say, I got this box and this box, but not that box. In other words, yes, maybe somebody did something wrong, but it didn't result in identifiable votes. We couldn't see it, and it didn't impact the outcome of the election. How many times did we see didn't impact the outcome of the election? 2 years ago, almost to the day. It's like a broken record here. Count 4. To the extent that the plaintiff can attempt to prove 1, the ability of the employees and the county ballot contractor to add ballots of family members, and the lack of an inbound receipt of delivery form both constitute misconduct. Yes, okay. The lack of an inbound receipt of delivery form both constitute misconduct. Okay. So these are the 2 counts. Hobbs's lawyers, they say, look, all right, Judge, everything else has been resolved. Neither of these 2 counts, neither of these 2 claims from Kari Lake have anything whatsoever, they put an underline on here, to do with the secretary, which is Hobbs, any of her or her office's deputies or responsibilities, or any personal knowledge she may have. Because they're saying, well, she doesn't know anything about printer malfunctions. She doesn't know anything about malfeasant people. She doesn't know anything about votes and how they could have been identified and any of these things. She also doesn't know anything about contractors or about their family members or the lack of a form. Well, we're not responsible for that. We're just the Secretary of State. What's left of count 2 involves specific allegations that a person employed by Maricopa engaged in intentional misconduct. But the secretary has nothing to do with Maricopa County's election day operations. I mean, that is a responsibility of Maricopa County. And what's left of count 4 is no different, as what's left of that deals with specific issues related to the county's ballot contractor and the alleged lack of an inbound form, which is a county form. And they're saying, well, she doesn't run the county. The secretary has nothing to do with the operations of the county's contractor, and certainly has no role in keeping or maintaining inbound receipts on delivery day. So therefore, Judge, they just say, look, though there was no good faith basis for the subpoena to begin with, that you granted, Judge, you idiot, is kind of what that reads like. There is absolutely no good faith basis to require the secretary to testify now, given that 8 of the counts in the motion to dismiss were granted. And to the extent that Kari Lake has any questions that are relevant, and there is simply no way that she could, in parentheses, Corey Lorick, the state elections director, has already disclosed as a potential witness who may testify regarding the Arizona Secretary of State's election-related duties and responsibilities and other matters related to the Secretary of State's office relevant to this case. Are they stupid? Who is Corey Lorick? She is the state elections director. All right. So if she runs the state elections and their defense here is that Katie Hobbs can't possibly know about anything because she's a state level representative. What they're saying is that Katie Hobbs is too big, right? Her position is too broad. It covers all of Arizona. What they really need is a Maricopa County person, because it's a Maricopa County ballot. It's Maricopa County. They operate the elections here. But then Katie Hobbs, they recommend a state elections director. What? They should be recommending a Maricopa County person as a substitute. Because this person, the state elections director, can testify about Arizona Secretary of State Hobbs's election-related duties relevant to this case. Yeah, I think the judge should deny this. I mean, this is ridiculous because what's happening in Maricopa County is a subset of what's happening in Arizona, right? You don't get to just say you run the whole state elections except that one county. Whatever they do is on their own. So they're trying to be very clever here. We'll see what the judge does. Signed off by Andrew Gayona, who is the lawyer, along with Sambo Duell from the United States Democracy Center. All of this going over to the Maricopa County Superior Court. Copying Blem Legal, which is the lawyer representing Kari Lake. Oh, look what else you have here. Christina Ford from Elias.Law. Oh, and you also see this organization right here. Yeah, Elias Law Group representing Katie Hobbs. Don't you see this everywhere? Everywhere. They're everywhere. They've infested the election litigation process all over this stinking country. All right, so Emily Krager, the Burgess Law Group, she's also from Maricopa County. Mark Elias and his whole organization, the Democracy Docket, right here. Pro hoc vice, flying in here, skidding in here, waiting to be approved pro hoc vice so that they can come in and join in on the fun. Oh, also Perkins Coie. Perkins Coie. Yeah, Perkins Coie. Yeah, the same Perkins Coie that was involved in the Michael Sussman saga. That's right, Perkins Coie. Michael Sussman, Jim Baker, they're representing Katie Hobbs as well. The DNC, the entire DNC, has come crashing into Arizona. Okay? The whole stinking party is here. Where are the Republicans? Where are they at? Are they anywhere? I don't see them. Is Mitch McConnell sending the RNC in here? Or any of his aides? No, of course not. Now, there's an exhibit that's also attached here. So Katie Hobbs submitted this. They said, below are the witnesses that the defendants may call at an evidentiary hearing. Defendants reserve the right. Kenneth Mayer, expert witness. Ryan Macias, expert witness. Okay. Oh, look, there it is. Christina Ford. So when did this email come in? Very soon, Sunday, December 18th, the Elias Law Group's now on the case. Christina Ford sends the case, the email from the Elias Law Group out of Washington, D.C. All right, there you go. So they're disclosing their witnesses. Now, it's not just Katie Hobbs who does not want to testify. She filed a motion to quash. Emergency, please don't make me testify. But you remember Stephen Richer. He's the other guy who used to stand right next to onesie-twosie Bill Gates, who used to say, well, it's total chaos around here, but, it's not that bad as long as we can figure out our onesies and twosies. All right, so Stephen Richer, Maricopa County recorder, also really does not want to testify. In fact, he so badly does not want to testify that he's just out of the country. That's how hard it is. Here's the submission. The motion to quash the subpoena of Stephen Richer, expedited because, boy, this is an election matter that's coming up soon. Kari Lake suing Katie Hobbs out of the Superior Court for Maricopa County. Bunch of people here on the docket. Deputy county attorneys and so on. Stephen Richer has gotten a subpoena to testify at the Kari Lake trial. On December 15th at 2:02 p.m., a process server delivered to the office of Maricopa County Recorder Stephen Richer a subpoena. Process servers coming in there. Issued by Kari Lake. The subpoena commands Recorder Richer's attendance to trial starting December 21 and 22, starting 9 a.m. That's tomorrow. But unfortunately, they write, well, because Recorder Richer will be out of the country on a long-planned vacation. I'm sure it was. On December 21st and 22nd. And two other employees of the Maricopa County Recorder's Office are well situated to testify regarding the claims of election duties. And three, because Kari Lake's claims about a violation of the First Amendment are not properly before this court, we move to quash the subpoena. So Stephen Richer is like, man, we're going on vacation. First, being required to appear for the trial will unduly burden Recorder Richer, who is the Maricopa County Recorder. Kind of a big deal. They say that beginning the week of December 19th, Recorder Richer will be out of the country on a long-planned family vacation. So he's already left. And he's already out of the country, man. So he left on a long-planned family vacation. And if it's his first in a long time also. It's his first vacation since taking office in January 2021. Okay, well, I guess in that case, the guy hasn't been on vacation since January of last year. Wow, so really hardship. So yeah, okay. Now the judge is going to be moved by this. Recorder Richer is going to have limited internet access while outside the United States. It's going to be very difficult, if not impossible, for him to testify remotely on this matter. No internet wherever he's going as well. Now, even if Recorder were available to testify, which he's not because he's not even here, he left. Under the Apex doctrine, they say he should not be required to appear to testify anyways, because other county employees can just, tell the story for him. They're better situated. Neither the Arizona Supreme Court nor the Arizona Court of Appeals is yet to consider whether to adopt this doctrine in Arizona. However, this court may consider these cases as persuasive. They say federal courts have regularly held that elected top-level government officials don't need to testify. And they say that Kari Lake's complaint and some of these things are within the purview of the recorder. But like all other defendants here, they say that the complaint should be dismissed anyways. So for the foregoing reasons, they ask that the court should enter an order quashing the subpoena as to Stephen Richer, because he's going to be on vacation. And he's not even in the country anymore. And there's no internet there because he is going to places where there's no internet. And am I making this up? Did he say he was going to Panama? Where did I see that? I thought I saw that somewhere. Maybe it's outside of this document. Anyways, he's out of the country. They don't even have the internet wherever he's going. I don't know exactly where he's going, but there's not even any internet. That's how far out of the country he's going. Okay, so almost impossible to get him to testify, and we'll see what the judge does about that. Now, the judge will issue rulings on those motions to quash. The judge already issued a ruling for an under advisement decision that he was going to make. Yesterday, there were a whole slew of oral arguments. We'll play some of these videos when we're off of the censorship platforms. But there are oral arguments that took place. We saw that Kari Lake's lawyer made some three, I think, pretty interesting arguments. One, he said that there was a secret censorship operation, which was obviously happening. That's on Twitter. He also included a bit about saying that there was evidence of intentionality, right? If there were printer problems that happened, it is likely that they were intentional. But the problem statement that I think that you two might have a problem with is when he says what that means, what the conclusions are. And so we'll save that for the after party or for another segment. But this is the under advisement ruling. Okay, after there were oral arguments that took place, and the judge took the matter under advisement, issued a ruling. We already talked previously about I forgot. This is where the Panama thing is. Okay, so before we move on to that, this is the declaration of Stephen Richer. This is what I screwed up. Yeah. So Stephen Richer says, I am the Maricopa County Recorder, right? So he submits that motion to quash. This is where we get more details. I make this declaration in support of my motion to quash the subpoena. This declaration is based on my personal knowledge. He says, I'm a Republican. I was first elected November 2020. I won this office by earning more votes than other people, and I took office January 4th. At 2:02 on Thursday the 15th, I got a subpoena to attend a hearing. But beginning of this week, December 19th, I will be in Panama. Do they not have the internet down there in Panama? I thought it was Panama. I'm pretty sure they have the internet down there. I would guess that they do. He says, my wife and I scheduled our trip, our vacation, many weeks ago. Many weeks ago. Huh. Well, that doesn't sound like that long planned to me. Because the election was many weeks ago. It is the first vacation that I have taken since I took office 2 years ago. Poor guy. Both by reputation and analysis, other people have said that I am one of the most present elected officials in Arizona. Look at Dylan Rosenblatt. He wrote an article for me on his Substack where he says that Maricopa County Recorder Stephen Richer badge scan shows that he goes to the office a lot. He might live there. As noted in Rosenblatt's article, I have averaged 6 days and 60 hours a week in the office since January. Yeah, well, hard worker. Now, while in Panama, I will have limited access to the internet, and it's going to be very difficult, if not impossible, for me to testify remotely in this matter on December 21 or December 22. Oh, they have no internet in Panama, and he's just not going to be able to make it work. Basically impossible. Yeah. Yeah, these are the guys who were in charge. I declare on a penalty of perjury under the laws of Arizona, the following is true. Signed, Stephen Richer, who can't get on the internet in Panama. All right. So this is the order. This is the final order that came out yesterday. The judge said that after the hearing with Kari Lake, he was going to be taking the matter under advisement. The order was filed 12/19 at 6:30 p.m. It is Kari Lake versus Katie Hobbs. You can see this is the under advisement ruling. So Judge Thompson listened to all of the evidence that was presented yesterday and decided I needed to think about this for a little bit, did that, and issued a ruling. Judge Thompson says, after considering the filings and the arguments of the parties and considering all of the facts and drawing reasonable inferences in a light most favorable to the non-movement, in that case it would be Kari Lake, the court finds as follows. So remember, at this stage, Kari Lake, Maricopa County Board of Directors, and others were filing a request to dismiss the case. So when there's an active request for dismissal, the law likes to presume that the non-moving party, the people opposing the dismissal, we look at the facts. If we have questions about the facts, is this true or is that true? Is this true or is that true? We don't know. And they're going to make a decision on that right after the trial, because that's when evidence is presented. So if there are questions on those things, what we do is we give the benefit of the doubt to the non-moving party. In this case, we're going to look at all the facts in a light most reasonable to Kari Lake. And if she fails on all of them, then we have to dismiss the case. Because even if we give her the benefit of every doubt at trial and she still loses, then we've got to dismiss it. That's not what happened here. Background. The judge writes, contestant Kari Lake initiated this election contest, filed her complaint and a special action, named Katie Hobbs as a defendant, and many others, including the Maricopa County defendants. We know these as Onesie Twosie Bill Gates. We know it as Stephen Richer, the Super PAC, and many others. On December 5th, Secretary of State Katie Hobbs published the official canvass for her own election, identifying 1.27 million votes for Kari Lake, 1.28 million votes for Katie Hobbs. Now, pending before this court are 3 motions to dismiss, all submitted by the defendants. The court heard oral arguments and pending motions on the 19th. They give us some discussion. They say that a court must apply all reasonable presumptions in favor of the validity of an election. Honest mistakes or mere omissions are not enough. An election challenger is required to structure her verified statement in conformity with the rules. And so the judge goes through each count, one by one. Kari Lake's first claim was about a violation of free speech. Says that they failed to protect free speech. They say that there are 2 acts of censorship of certain social media posts. And this ties directly back to the Twitter files. Kari Lake complains. She says that evidently Secretary Hobbs and Stephen Richer, they submitted certain media posts to CISA and through their election misinformation reporting portal, the recorder's presentation to CISA and others about election misinfo. Okay, they're asking for censorship. They're probably communicating with people like Yoel Roth. Now, it says it's unclear after briefing what legal argument Kari Lake is attempting to make. The judge says that this claim is going to fail because there's no state action, which I disagree with. First Amendment restrains the government. Okay, so it's a whole First Amendment analysis. In conclusion, the judge says this must be dismissed, right? These are these constitutional claims, I think, are long shots because the judges are just not, they don't entertain them. They want to see more factual approaches. Like, what is this judge going to do? Is he going to order action taken against CISA and the entire national security apparatus, the entire intelligence community? No. So the judge is just going to get rid of that. Now, locally, we have another issue. Illegal tabulator configurations. The judge analyzes count 2, the complaint. Kari Lake says that the ballot-on-demand printers that malfunctioned were not certified, that they've got vulnerabilities. There's a declaration attached. Kari Lake alleges separately that the printers malfunctioned because of intentional action. Plaintiff alleges that these combine to provide grounds for setting aside the results. The judge is saying, here's what I think Kari Lake is arguing. 1, the printers lacking certification was misconduct by some responsible official. And 2, someone did something to the printers to cause them to misprint ballots. Now, the former issue, like they just lack certification, is not enough, because it's kind of an absence of something. But going further, arguing that the printers failed because of some intentional involvement is enough. The judge says, while the court finds that Kari Lake does not state a claim under the first provision, the court finds that she does state a claim under the second. Viewing the complaint from Kari Lake in a light most favorable to Kari Lake, it says Kari specifically alleges that a person employed by Maricopa County interfered with the printers in violation of Arizona law, resulting in some number of lost votes for the plaintiff. Therefore, that's enough to get her over the line. Kari Lake is entitled to attempt to prove at trial that all of those other 3 things mattered. There was a malfeasant person, checkbox 1. That malfeasant person caused malfunctions, checkbox 2, that identified lost votes. And number 3, the votes affected the outcome of the election. All of that will be debated at trial, and that will stand at trial. Those are the elements that Kari Lake has to prove. So enough to close the margin. They've got to come up with an individual, okay? Identify somebody. Somebody, like a name. And that the malfunctions were malfeasant, right? That person did it. It wasn't an accident. Kari Lake tried to cite Hunt, but nevertheless has alleged that intentional misconduct is sufficient to move that part past this dismissal. The judge says the court takes no position as to the evidentiary weight that's going to come out at trial, but the evidence is not before the court at this current motion to dismiss stage. And so this will move forward. Defendant's motions are denied as to count 2 as narrowed above. All right, so really tighten that up. Now, the next charge, the next complaint that Kari Lake proffers is invalid signatures on the mail-in ballots. The judge says that Kari Lake next argues that the methodology used by Maricopa County is out of the law, doesn't comply with statutes. The defendants claim that that is not so. Considering Kari Lake's delay, Kari Lake makes much of a report from Mark Brnovich. He wrote out a general saying the signature verification program in Arizona is problematic. Yeah, and so in other words, this is too late. To the extent she relies on a review of 2020 ballots, the report that she relies on here is in June. It's months before the instant election, so she can't rely on that. So count 3 goes away. Now, count 4, I think, is a very interesting claim, and this one we can play a clip of. Let's play this clip. I think this is the one.
Talk about the chaos on Election Day, Your Honor, and the evidence that we have put forward to support intentionality. We have introduced the expert sworn declaration of Clay Parikh. Clay Parikh is not just any cyber expert. Among other things, he spent 8 years being retained by the voting system testing lab, the Pro V&V, that certified these machines for Maricopa County and many others around the country. He knows these machines. He's a top cyber expert who has been at the highest levels of the government working on cyber systems. He knows the rules, what EAC certification requires. He understands these machines. He knows systems. And he has given a sworn declaration that goes in detail how Maricopa County violated their own set procedures, both in terms of the pre-testing to ensure that the debacle that happened on November 8th doesn't occur. He has gone through the procedures that are supposed to happen if there's any issue on Election Day. He has interviewed the T-Techs and the other technicians that Maricopa County hired on a temporary basis. And as he said, you don't get, whether it's 70 vote centers or 132, as we said, you do not get that system-wide failure without intentionality.
So they are saying that the setting change was so massive, right, that it had to be an intentional setting change. It wasn't like just an accident. So you can see that was about intentionality. I think he talks here about a little bit about chain of custody. Let's listen to this one.
a repeated issue for the county. They're on notice of these. And these are mandatory requirements by statute under 16621E. The county is required to maintain chain of custody every step of the way with the ballots. And it's a criminal violation not to do it. That's how serious chain of custody is. It's not some ministerial act. The EAC says that the chain of custody is one of the most critical features to ensure the integrity of the election. And what defendants ignored in our complaint is that on November 8th, if the chain of custody procedures had been followed, Maricopa County should have had an exact count of the number of ballots that they had. That's the process that the law mandates. On November 9th, they reported the amount of ballots that they had. On November 10th, mysteriously, 25,000 extra ballots appeared.
Yeah, and so chain of custody, as you heard from that beginning phrase, he says that is a huge part of this analysis, which is absolutely right. The analogy that we can carry over from criminal law is if you get stopped for a DUI, for example, there's many times a DUI case involves, 4 or 5 officers. When you involve the crime lab, it involves many other people. But in some situations, you might have one traffic officer who conducts the traffic stop, another person who comes and does the DUI investigation, another person who's the phlebotomist who draws the blood, another person who transports the blood, another person, you get the picture. Now, the problem here is if you draw blood from a person and it goes from Officer A to Officer B to Officer C, Officer A is the phlebotomist, draws the blood, gives it to Officer B, who transports the blood. Officer B gives it to Officer C, who impounds the blood. What happens if Officer B goes away? Is the blood still reliable? Can you still rely on that as a valid sample? No, you can't. Why? Because you can't talk about Officer B. You can't confront him. You can't ask him what he did with that blood when it was in his possession. Did he literally swap the samples? Did he put the blood sample in a microwave? What did he do? Did he contaminate it somehow? There's a million things that could be problematic here. He could relabel the whole vial and just swap the whole thing out, right? We don't know. So the question becomes, if in criminal law, that would invalidate the entire blood draw, right? That entire bit of evidence would be thrown out. Why wouldn't that also happen in an election? In a situation where somebody's transporting the ballots from A to B to C, and we don't know what happened with B. Feels like it might be a pretty big problem. The judge tends to agree. The judge says that count 4, ballot chain of custody, is a big issue. Kari Lake says that violations of the county election manual pertaining to chain of custody constitute misconduct under the law. Kari argues that 1, the ability of employees of the county's ballot contractor to add the ballots of family members, and 2, the lack of an inbound delivery form both constitute misconduct. This is an allegation to complaints, in addition to complaints, about the handling of the ballots in the 2020 election. In addition to the complaints. So they're not using them, right? The other one up here is where they were trying to use those, and the judge said no to those. The election about the prior election has no bearing on this. The court does not consider them, right? So the judge is specifically excluding any 2020 stuff. Kari Lake alleges that of some number of ballots were added by Runbeck employees to the total in violation of the law. Kari Lake also says that the lack of a delivery form were violations of state law that permitted an indeterminate number of votes to be added to official results, constituting misconduct. The court, drawing inferences in a light most favorable to Kari Lake, as it must at this stage, finds that Kari Lake has stated a claim of misconduct by a person under control that affected the canvass under the law. Now, they say that laches applies. However, they say that laches do not apply to contests arising from a violation of Election Day procedures as a result, as opposed to challenging the procedures themselves. All right. So, in other words, laches say you can't file a lawsuit to change the rules after the rules were used. But if you lose the game, you can't go back and change the rules. But if you lose the game because there was a violation of the rules, well, you can challenge that. The state is sort of misconstruing what laches are. The judge is calling them on that. So it says that the government disputes the lack of compliance with the chain of custody laws, and they claim that Kari Lake has misunderstood the forms required. But the judge says, as presented, whether the county complied with its own manual and applicable statutes is a dispute of fact rather than one of law. And so this is true as to whether such lack compliance, whether it was intentional or whether it did, in fact, change the outcome. So the judge is saying, we need to hear more about this, right? What is the actual evidence? And then the judge will make a decision after that time. Now, all of the other counts were dismissed. So count 5, equal protection, and count 6, due process. Kari Lake said that there was intentional discrimination. Doorbell rang. So we're doing a quick pause. It's Christmas time. I have to get the package. Don't go anywhere. I'll be back in 30 seconds. All right, it's here. We got it. Yay. All right, so we're going to carry on. It wasn't the FBI. I get a little nervous. It was actually the package. And we're back. All right, so now we can carry on. The other counts were ultimately also dismissed. So you can see counts 5 and 6. Kari Lake was making the argument that there were various facts that constituted intentional discrimination and a due process violation. Even if the court assumes that there were violations of equal protection and due process, such violations are not necessary to an election contest. They're kind of saying, yeah, there were some due process. If an election is problematic, there are necessarily other constitutional problems. And so we don't really need to cover that here. Secrecy clause. She says that the mail-in ballot procedure is unconstitutional, also saying latches conclusively bars this challenge because this is the opposite example of that. This is now trying to change the rules after the fact, not change a violation of the rules. Lake could have brought this challenge at any time in the last 30 years, she says. So you don't get to do it here. Incorrect certification. They say if this court invalidates the election, then maybe there would be a claim against Hobbs. But right now, any claim against Hobbs is premature because Hobbs has not been found to be involved in any misconduct. So count 8 has to be dismissed. Count 9 is about an inadequate remedy. The judge says it's probably a remedy here. And counts 10, she says that in Arizona, in Maricopa County, they violated the Constitution. The judge says, nope, that's also dismissed. So in conclusion, Judge Thompson writes, it is ordered dismissing all counts of Kari Lake's statement of election contest, except for counts 2 and counts 4, chain of custody and malfeasance. Further ordered, prior order about ballot inspections is confirmed. That took place December 20th. And it's further ordered accepting and adopting Maricopa County's recommendation, appointing a constable. Lynn Constable is the court's inspector. Now we have further orders from the court. The court originally allocated 2 days for the trial, but that allocation of time was based on 9 counts. The ruling on the motion to dismiss has reduced the number of remaining counts substantially. Therefore, the trial that starts on Wednesday, the 21st, the original time should be more adequate to accommodate a full hearing on the merits. The compressed time for presentation is not based only on time constraints imposed by the law, but by the parties' expressed desire to leave at least some time to file an appeal before the court's rulings in January. The time allocated means each side will have 5.5 hours available for opening statement, direct exam, cross-exam of opposing witnesses, redirect, and closing argument. 30 minutes deducted from each side's 6 hours for a 15-minute break in the morning and afternoon. It's also further ordered that the parties shall meet and confer to provide the court with the list of witnesses to be called, and opening arguments due by Tuesday at noon. The judge also wants to see any exhibits marked no later than noon. And those are the final orders coming out of the Maricopa County Superior Court case involving Kari Lake and Katie Hobbs. We will, of course, continue to cover this because we are here in Arizona, and here is our law firm, the R&R Law Group. If you happen to know anybody in the state of Arizona that is facing criminal charges and they need some help. We have an awesome team. We love to help good people charged with crimes. Visit us online, rrlawaz.com, or call 480-787-0394. We'll continue to cover all of the Arizona stuff, including the developments here. We're going to have a trial. We'll probably hit some of the highlights the day after the trial. I know others are going to be live streaming it and covering it live, but we'll probably consolidate it and just hit the highlights. So all in all, interesting ruling. It's very good news that the motion to dismiss was not granted. Obviously, you'd like to see some more counts stick, but I sort of agree. Some of those were duplicative. The ones that I was very happy to see were left on there. The one in particular was the chain of custody issue. I think that's a huge problem in criminal law. That's catastrophic to the government's case. We'll see how that holds in Kari Lake's lawsuit, but we'll continue to cover it. Thank you for joining us as we do. Thank you for hitting the like button wherever it is you're watching this, and we'll look forward to seeing you on the next one.